I don't think there's any board that can prevent getting hacked. The question is, what's the director's liability? How is that mitigated? And what's the process for mitigating it?
Well, it's a good question, TK, and it's one that many directors ask me, and when I give them the advice I give them, it's couched in this way. Directors have duties of care and loyalty. That's their basic fiduciary duties, and out of those duties comes the duty of oversight or monitoring the corporation. So, for example, they have to oversee the company's compliance with legal requirements. And in the cyber area, they have the same kind of oversight responsibility. And there was a famous case in Delaware, a landmark decision really called Caremark, where this duty was explained. The board's obligation is to establish a system that will monitor whether it's legal compliance or whether it's monitor potential data security risks, and that the board then, after it establishes that system to do that, that it actually has a way of following and making sure if any red flags pop up that show some risk, that they are responding to it. That's a very high standard to show that a director has breached that duty, and it's a very difficult standard, probably one of the most difficult under corporate law today to meet, for a plaintiff shareholder to meet. And so as long as there's a system that's been established by the board, and so long as they're monitoring it and paying attention to the reports that come up through the committee that the board has assigned this duty to, and then to the board, and they act on whatever recommendations management or the experts that they've hired, they may need outside experts to advise them on this, and I recommend that many times. That's the test. Have they created a system to monitor the compliance and the oversight of the security risks? And are they addressing any deficiencies or weaknesses in that and responding to them in a timely way?
Now, you say that the bar is high, okay? But it seems very basic if a court case comes up and the board was not involved, meaning there's nothing in the minutes to reflect that they had discussions on this. There's nothing to reflect that there's been processes, oversight by the board. That doesn't seem very high, if
well, you're right.
If they're void of that.
Right. If you don't have a process that's reflected in a record in a way that a judge or a reviewing body can see, then you've got real problems. I often use this old metaphysical story of if a tree falls in the forest and there's no one there to hear it, does it make a noise? The corporate law analog to that is if a board of directors follows an exemplary process but has no record of it, will a judge still respect what the directors did? And so you don't want to find out the answer to that. You want to be sure that you've got a record that reflects what you've done in the way of designing that process. So your minutes, your reports, and so on document what you did. That's the key ingredient.